Registrar, could you call the case?
Good afternoon, Your Honor. This is case number IT 0475 PT, the prosecutor versus Goran Hadžić.
Thank you very much. Good afternoon to you all. May we have the appearances, please, starting with the prosecutor.
Good afternoon, Your Honor. My name is Douglas Stringer. I'm appearing on behalf of the Office of the Prosecutor. With me today is Laurel Begg, who's an attorney with our office, as well as case manager Thomas Logel.
Thank you.
Good afternoon, Your Honor. For defense of Mr. Goran Hadžić, Zoran Živanović, lead counsel. Thank you.
Thank you. May I confirm with Mr. Hadžić that he can follow the proceedings in a language he understands?
Yes, it's fine.
Thank you. So this is the first status conference in this case. The purpose of this conference, pursuant to Rule 65 bis A, is to organize exchanges between the parties so as to ensure the expeditious preparation for trial. It is also to allow Mr. Hadžić the opportunity to raise any issues in relation to the mental and physical condition in detention. There was a Rule 65 third conference held last week on the 4th of November, at which the parties and the legal officer of the Chamber discussed various issues related to the pre-trial preparation of the case. The Chamber has been informed of what transpired at that meeting, and it wishes to thank the parties for their participation in that Rule 65 third conference. I also commend them for the spirit of cooperation that was demonstrated at that conference. In relation to pre-trial preparation, I note first that all of the material supporting the indictment has now been disclosed to the defense. I also note that the briefing has been completed for the defense's motion alleging defects in the form of the indictment, and I'm very grateful to the parties for adhering to the deadlines for that matter. And the Chamber will issue its decision on the motion very soon, probably today. I acknowledge receipt of the prosecution's letter of the 2nd of November about disclosure. The information contained therein is a useful tool for pre-trial preparations. The prosecution has agreed that it will file on a monthly basis a report along the lines of the letter, detailing its progress and a variety of tasks that it must complete. If necessary, that report may be filed confidentially. For example, if there is discussion of Rule 70 material, but I would encourage both the prosecution and the defense to make as much material as possible available to the public, and only to designate filings as confidential when it is strictly necessary, so that the proceedings can be transparent and open to the public to the greatest extent. I note that the prosecution filed its first of such reports yesterday and did so publicly. I would now ask the prosecution to report on the state of Rule 68(1) disclosure. Mr. Stringer?
Thank you, Your Honor. As indicated in the report that was filed yesterday and in our earlier letter to the trial chamber, we've been in consultation with the defense about issues that might assist in the identification of Rule 68 material. so that we can disclose it to the defense as quickly as possible, as well as identify it. Along those lines, the parties have agreed that a number of prior cases here at the tribunal serve as a basis for disclosure generally, not just Rule 68, but certainly including Rule 68. Along those lines, or I should say in addition to looking to the prior cases, the prosecution, as indicated in our report, has already completed one of the database searches that we intend to undertake during the pre-trial phase, a database search intended to hit documents that bear the name of this accused. And that search was undertaken. It is still in the process of being reviewed, but it has been reviewed to at this point to enable us to identify what materials are confidential versus what materials are not confidential. All of the non-confidential materials have been disclosed to the defense already. That was done last week, I think on the 4th, on the day of the 65 term meeting. So all of those documents have been made available to the defense. Now that includes anything that might be Rule 68 material, but it's certainly all relevant material in that all of these documents are going to contain the names Goran Hadžić or President Hadžić. So that's the first disclosure batch that has occurred, and that process is going to continue. Now, in terms of the other prior cases, anything that was previously disclosed in those cases as Rule 68I material is also going to be disclosed to the defense in this case as potential Rule 68 material. We're always a bit reluctant to make, some materials are readily identifiable as exculpatory or falling within the scope of Rule 68. Other materials might fall within the scope of Rule 68, but it's not so clear to us because at this very early stage, it's not clear to us what the defenses are and what issues might be of relevance to the defense for purposes of Rule 68. I can assure the trial chamber that we are intending to take a very broad view of disclosure. It's going to be essentially an open file policy. Anything that's relevant is going to be disclosed. And that's the principle that we're going to be following in the coming months of the pretrial phase. So an initial disclosure has been made. We expect that it would contain Rule 68 material. We are now going through those individual documents ourselves and looking at each one, and to the extent that specific documents are identified, which then would, in our view, constitute Rule 68 material, we will specifically identify those documents for the defense. And so he already has all of this initial batch of documents that's not confidential. We are now going to put our eyes on every one of those documents individually and direct the defense to specific documents which, in our view, would fall within the scope of Rule 68. And it is our intention to continue to act along those lines on these database searches that we perform. It's time intensive, as I indicated in the status report. There's a tremendous amount of documentation, and it takes a lot of time to identify them and to look at each one and to make this determination. I think that we are certainly going to continue to do that on documents that are confidential, that is, documents that are not readily available to the defense, to ensure that there isn't anything that's confidential that would contain Rule 68 material. So our focus is going to be on non-confidential, or I'm sorry, on the confidential materials to ensure that everything that's not already available to the defense has been individually examined for purposes of Rule 68. And so that is a general overview of our approach to Rule 68 with some initial information about the disclosure that's been made thus far.
Microphone, please.
I'm sorry. Thank you very much for this detailed report, Ms. Stringer. Following the Chamber's decision on the preliminary motions of the defense, an order will be issued with deadlines for the following actions of the parties: the prosecution's witness and exhibit list, the prosecution's disclosure of witness statements and transcripts as well as exhibits, the prosecution's pre-trial brief, the prosecution's disclosure of expert reports, the defense's notice of whether it intends to cross-examine these experts, the defense pre-trial brief, any Rule 92 bis and quarter motions from the prosecution, and the defense notice of any alibi or special defenses. A date will also be set for the pre-trial conference and the start of the trial. In respect of the disclosure by the prosecution of witness statements and transcripts, I note that the prosecution has indicated that it is prepared to commence this disclosure subject to the Chamber's decision on the prosecution's second motion for protective measures for victims and witnesses and documentary evidence, which was filed on the 1st of November. The Chamber is awaiting the defense's response to that motion and will decide the matter as soon as possible so that this disclosure can proceed apace. I would invite the prosecution and the defense to make any comments they wish on the proposed pre-trial work plan. Mr. Stringer?
My only general comment at this stage, Your Honor, would be that the prosecution considers us to be in quite an early stage of the case. The arrival of this accused, who was a fugitive for some 7 years, I think just a few days short of 7 years, is something that has obviously generated a tremendous amount of activity and work in our office in our pretrial preparation. However, having said that, it wasn't previewed when the accused would arrive, and if I may say, in an era of downsizing, this has presented specific challenges to us, which we are addressing in our pretrial preparation in terms of staffing and otherwise. We will continue to prepare to meet all the deadlines, and we'll do everything possible, obviously, in order to put ourselves in the position to meet any deadline that's set by the trial chamber. We are in the process of contacting witnesses now. The events of which this trial will be about occurred some 20 years ago. The fall of Vukovar was 20 years ago this month. Age is a factor. It's affected our witnesses and their availability. We're in the process of contacting now to inform them of these developments and of our pretrial preparation. It may be that we're called upon to ask the trial chamber to consider adjustments to the witness list as we go along and as we learn about the availability or the lack of availability of witnesses. As I've mentioned, in terms of disclosure, because we are looking to the prior cases, there's a tremendous volume of documentation that's involved for disclosure purposes. And it takes us time to identify the parts of some of these cases that are relevant, because it's not our intention to burden counsel by simply disclosing all the documents that come from a different case. Because, for example, in a case like the Slobodan Milosevic trial, only a part of that case is of relevance here. And it's not our intention to dump everything on counsel. Rather, we have to identify the documents that we view as relevant. And it's the same for the Stanisic-Samatovic case, of which there's substantial overlap, but not total overlap with this case, and the Shechel case as well. As Your Honor knows, these are all accused who are co-JCE members with this accused, as alleged in our indictment. But it's our intention to be selective in terms of what we use and what we disclose, so that the trial chamber and also the defense is not burdened with the tremendous amount of documentation that's possibly of less relevance. The point of that is that all of this takes time, and we would hope that the trial chamber would factor all of this into its consideration in setting the deadlines for the various filings and notices that will be coming in the course of these pretrial proceedings. Thank you.
Thank you very much for that information, Mr. Stringer. Mr. Zivanovic, do you have any comment on the...
Your Honor, I have no comment on the proposed pretrial work plan. However, I would like to inform the trial chamber about the problem we have in the composition of our defense team, and I apologize since I did not put this issue at the 65th conference. Please, could you move into private session, please?
Can we move into private session, please?
Open session.
Thank you very much. I would like to raise now the issue of agreed facts. I would encourage the parties to meet as soon as possible to commence discussions on whether any agreement can be reached on facts that are not reasonably in any dispute and thus could be submitted to the chamber as agreed. I would be interested to hear from the parties on that matter, especially whether they think they would be in a position to report back to the chamber on their progress in this matter by the end of January, the 31st of January 2012. Mr. Stringer?
I believe certainly on the side of the prosecution there would be no difficulty in conferring with counsel on the possibility of agreed facts and reporting our progress to the trial chamber within that time period.
Thank you. Mr. Zivanovic?
Yes, I agree with it.
Thank you very much. The final matter I wish to raise is that of adjudicated facts. I'm minded to set a deadline for any adjudicated facts motion for a date after the prosecution had completed its disclosures obligation under the Rule 65 ter E 2, 3, Rule 66A 2 and Rule 65 ter E 3, and after the prosecution has filed its pre-trial brief. Moreover, I would prefer one single motion rather than a series of motions. Based upon the information in the possession of the chamber after the prosecution has completed its disclosure, it is possible that there may be a limit placed upon the number of facts to be submitted by the prosecution. A Microsoft Excel spreadsheet has been sent to the parties in which I have proposed a format for any adjudicated facts motion. I would ask the parties to use that format so as to organize our work as efficiently as possible. I would be interested to hear any comments from the parties on these guidelines for any forthcoming motion requesting the chamber to take judicial notice of adjudicated facts. Mr. Stringer?
Your Honor, we welcome the suggestion or your inclination to put the adjudicated facts at a later stage until after not only the parties, but perhaps the trial chamber itself has a greater command of all of the evidence and the issues. I think we're all in a better position to propose adjudicated facts at that time and for the trial chamber to then consider them. So we welcome that, and of course we'll do that within the format that the trial chamber prefers.
Thank you very much. Mrs. Jivanovic? Thank you. At this point, I would like to ask Mr. Hadžić whether there are any issues in relation to his case that he would like to raise today. This may include, Mr. Hadžić, issues regarding your mental or physical condition while in detention, and please be assured that we can go into private session for these purposes if you would prefer.
There is no need for that. I feel all right, and I am quite content with the conditions in detention.
Thank you very much. Are there any other matters that parties wish to raise today?
Not from the prosecution, Your Honor.
Mrs. Ivanovic?
Not for defense. Thank you.
I thank you kindly for your appearances today. I thank the parties for their mutual cooperation in getting this case ready for trial. A scheduling order for the next Rule 65 third conference and the next status conference will be issued in due course, and this status conference is now adjourned.
All rise. We will